Hi, I'm Joe Patton with Patton & Patton Personal Injury Lawyers. I'm going to chat with you a little bit today about hit and run auto accident cases. A lot of times, you get in an accident, the other driver takes off. A couple things you need to be aware of so that you can be fully compensated in that situation. First of all, do whatever you can in a situation like that, of course, to try to document who that person was. Pull out your cell phone, video, even photographs of the individual, particularly his license tag, car, stuff like that. Sometimes they take off um, before you get a chance to talk to them and do any of that, and you really honestly don't know who they are. The nice thing under the law is that if it turns out someone else was at fault and they caused injury to you for personal injury, you can make what they call an uninsured motorist claim. What that means is everyone's familiar with auto accident insurance because in Kansas and most states it's required that you have that before you can legally drive your vehicle. And in Kansas, you have that same requirement. The law provides, though, that uh, if you're there's various sections of the insurance policy that apply in an auto accident. You've got what's called the no-fault PIP parts, which pays loss of wages, medical, and other benefits, and then they pay that regardless of who's at fault. Then they get reimbursed later. You have what they call liability coverage, which protects you if you're at fault, or if the other driver is at fault, you can make a claim against the other driver's liability policy. That other driver owes you the medical bills, loss of wages, economic loss, non economic loss, including pain and suffering, permanent disability, and a number of other kinds of things. And usually, then, the demand is made upon the other driver. He turns it into his liability insurance, and they'll hire an adjuster or a lawyer to defend him and settle the case. That's a liability claim. But what happens when the other driver is just not insured or takes off? If he's uninsured altogether, or, and today we're going to be talking about just a hit and run situation. If they hit and they take off, and there's no insurance that you can find, then you want to make an uninsured motorist claim against your own automobile insurance company. You make the claim against your own company because when you bought your policy, there was a provision in that policy that says if someone hurts you in an auto accident and they're at fault and they're not insured, your insurance company will step in and act like the insurance company for that person and pay your claim. And then they have the rights to turn around and go against the person that's actually the wrongdoer. And it works out usually to your benefit to make the claim, particularly if you can't find anyone else as far as a liability policy to pay. Here's the rub, though. Sometimes a person's at fault and there's no actual physical contact between the two vehicles. And the Kansas statute is kind of strange on that. What it says is you can make an uninsured motorist claim, but it says, and I'm going to quote this, when there is no evidence of physical contact with the uninsured motor vehicle, and when there is no reliable, competent evidence to prove the evidence or facts of the accident from a disinterested witness not making a claim under the policy, then the insurance company can exclude that kind of claim. So there should be physical contact for you to make and be able to prove the claim. And if there's not physical contact between the vehicles, then in order to make the claim, you have to have what's called reliable, competent evidence. In other words, you have to be able to prove that it actually happened, and you got to be able to prove it actually happened from disinterested witnesses, people who are not making a claim under the policy. That could be another driver, it could be a neighbor, it could be a bystander, it could be a police officer. We have even been able to prove that the accident happened by reliable physical evidence from the scene of the accident. But if you haven't got any of that, they're not going to allow you to make an uninsured motorist claim if the only evidence you have is damage to your vehicle and just your word for it. They need reliable, competent evidence. So remember, if you're ever in an accident, if there's any witnesses around, you got to make sure you get their name and contact information and store that, because that could be vital later. Otherwise, your claim might be denied altogether. And that is only in the situation of a hit and run situation where there's no physical contact. If there is physical contact, then that provision doesn't apply and you can make an insurance claim. And we have links below that will talk about information that you can get from our office concerning how to handle an auto accident case, even if you're not going to hire a lawyer, how to handle property damage claims. And we'll give you links for more information about uninsured motorist provisions and what a lawyer can do to help you. So that is basically the situation with uninsured motorist hit and run insurance claims. Nice talking with you.